Let's talk about how impaired driving investigations work in Canada, because there's a lot of confusion around what actually happens when you're pulled over or go through a roadblock or are investigated for impaired driving. The first thing, the most important thing, is the officer stopping or detaining the individual. And obviously, without a stop or a detention, there's no investigation that flows from that results in breath tests or blood tests or anything like that. Police officers in Canada can stop people at random anytime they are on a roadway for the purposes of checking their sobriety, their insurance, and their fitness to drive. This means that if you are driving down the road, you could be pulled over at any point by a police officer and they can come up and ask you about whether you have a driver's license to produce it and ask you questions about drinking. You don't have to answer the questions about drinking, but that's what the police are entitled to do. Most impaired driving investigations in Canada start with a stop. It starts with the officer pulling the person over and then determining that they're going to conduct a sobriety test. There are other circumstances, though, in which police officers may decide to engage with an individual for the purposes of checking their sobriety. Sometimes the stops are not random for the purposes of checking sobriety, but targeted for this purpose. And I'm referring to situations where police officers park outside bars, popular restaurants, nightclubs, or liquor stores, and then pull people over for the purposes of checking whether or not they've been drinking. In such circumstances, the officers will engage with the person, but they're determining to stop them based on them coming out of the establishment or being in a place where alcohol is served, as opposed to just seeing a car on the street and pulling them over at random. Obviously, another common example where the sobriety-related investigation may occur is a situation where somebody is pulled over on the basis of some sort of violation of the traffic law, whether it's speeding or failing to stop at a stop sign or maybe going through a yellow light when you had time to stop. Anytime there is the officer observing an offense, this also opens the door to them deciding to check sobriety. And another really common way in which sobriety interactions come up with police is situations where police pull people over on the basis of a report from a civilian or oftentimes servers or people at liquor stores who observe somebody who's intoxicated or who's been drinking, leave an establishment, and then call to report them in. Another very common one that is probably pretty obvious is situations involving accidents, where police officers arrive at the scene of an accident and after arriving at the scene of the accident, start to investigate whether or not the accident was caused by a lack of sobriety. These are some of the things that can trigger these stops. The last thing, and this one's a little bit more complex and a little bit more tricky, is situations where officers pull people over situations where officers don't pull people over, but instead situations where officers are investigating in response to a complaint and attend at the address of the person. This is an area of law in Canada that is right now hotly contested. There's a Supreme Court of Canada decision on reserve about whether officers are entitled to go onto somebody's property to knock on their door and question them about a sobriety-related report, a report of impaired driving, or whether that is a violation of a person's right to privacy and an illegal search and seizure. These are very interesting issues, and hopefully we'll have an answer from the Supreme Court of Canada soon about the scope of that authority, but you can rest assured that it's something that's being tested. In all of these circumstances, the next thing that's most likely to happen is a roadside breathalyzer test. The police are entitled to conduct a roadside breathalyzer test in one of two circumstances. The first circumstance is a situation where the police are conducting the roadside breathalyzer test for the purposes of determining whether or not somebody has alcohol in their body at an impermissible concentration. And this is done when they form a reasonable suspicion that the person has alcohol in their body. This requires that the officer have a reasonable basis to suspect this. It must be subjectively believed by the officer, but that belief must also be objectively reasonable. Generally speaking, what's going to qualify for a reasonable suspicion is going to be an odor of liquor on somebody's breath or an admission to consuming alcohol. Those aren't required, although it is rare that there would be a reasonable suspicion absent an admission or an odor on the breath, but it is still possible. If there's a constellation of other factors that may point to alcohol being in the person's body, then the officer could still form a reasonable suspicion and ask for the test. But officers also can do the test without forming a suspicion, without any grounds whatsoever. And in that circumstance, all the officer has to do is be in the lawful execution of their duties. Basically, they've lawfully stopped the person. 2, they must be in possession of the approved screening device, so they're not waiting for it to be brought to the scene or anything like that. And 3, if they're in possession of the approved screening device, the demand for the sample has to be made immediately to a person who is operating a motor vehicle. This is a very important distinction in the law because the language used in the criminal code between is operating in the case of the mandatory demand, where there's no suspicion required, and the language in the suspicion demand, which applies to circumstances where the officer has reasonable grounds to suspect alcohol in the body of the driver and that the person has operated or had care and control of the vehicle within the preceding 3 hours. So you have this time sort of buttress that you get with the suspicion demand that doesn't apply to the mandatory demand. And although this is not settled law in Canada at this point, it seems to be, from Parliament's drafting and choice of language, that the mandatory demand would not be able to be used in circumstances such as where an officer shows up at somebody's doorstep and asks them to provide a sample, or circumstances where the officer is arriving at the scene of an accident and doesn't see the person operating the vehicle. They're out of the car, they're in the back of the ambulance getting treatment or something like that. Then they wouldn't be dealing with somebody who is operating a vehicle. Again, the law on this is not settled, so I wouldn't recommend, obviously it's a criminal offense to refuse to comply with a breathalyzer at any point, but I wouldn't recommend trying to gauge the validity of the demand roadside with resort to those things. The immediacy requirement, the requirement that the demand and test be done immediately, applies to both the mandatory and the suspicion-based demands. This means that an officer who forms that suspicion or who decides to read a mandatory demand must read the demand immediately after the suspicion or immediately after the subject is encountered by police. And then, after reading that demand, the sample must be provided immediately as well. That means there's an obligation that goes both ways. There's an obligation on the police officer to conduct the test and give the person the opportunity to comply immediately, and there's an obligation on the individual who's given the demand to comply with that demand immediately, to immediately furnish the breath sample. But there are exceptions, and the exceptions to immediacy that exist in Canadian law are: 1, circumstances where the officer has a reason to delay the test related to the operational requirements of the device. We're talking about things like residual mouth alcohol contamination, which we'll discuss in another video, situations where there might be interference with the sample as a result of smoking, vaping, objects in the mouth that affect mouth temperature, anything that might interfere with the sample that requires a delay for the proper administration of the test. That's an exception to the immediacy requirement. The Supreme Court of Canada ruled many years ago in a case called Burnshaw that in circumstances where there is this exception to the immediacy requirement, what the officer should be doing is reading the demand immediately and then delaying the test and advising the person of why they are delaying the test. This is because they're telling them the reason for their detention, a charter-protected right under Section 10A of the Charter. Now, as far as the other reason why tests could be delayed, it relates to unusual circumstances. There's no legal definition of what unusual circumstances is. It may be officer safety, depending on the totality of the circumstances. It can't be a vague or unjustified concern about officer safety. It needs to be a legitimate officer safety concern arising out of those circumstances. Or it could be something like the subject runs away and the police have to chase them, right? Something like that, something they could not anticipate or plan for. What unusual circumstances does not encompass, however, is this question of whether or not the police officer is in possession of the device. Even though there's no statutory requirement for the officer to be in possession of a roadside breathalyzer in situations where they read a suspicion-based demand, as a practicality, they do have to be in possession of it. And this is because being in possession of the device facilitates the immediate provision of the sample. And the Supreme Court of Canada has ruled that waiting for a device to arrive is not unusual circumstances that couldn't be controlled by the police. Police resource issues do not get to override your rights. Police need to resource their officers and their teams correctly to conduct these investigations. So if you provide a sample into a roadside breathalyzer and you fail the test, then you're going to be arrested and you're going to be read in a criminal investigation We'll discuss the 90-day immediate roadside prohibition in BC in another video, but you're going to be read a demand to provide further breath samples at the police station. But the police don't actually have to do the roadside breath test. It's not required that the roadside breath test happen. If they come upon you in the context of any of these impaired driving scenarios where they can stop you or detain you initially, and then they form reasonable and probable grounds to believe that your ability to operate a motor vehicle is impaired by alcohol, then they can make the demand without doing the roadside breath test. They can go straight to the arrest and straight to the demand for breath samples. And in those circumstances, the officer is subject to different timing requirements. So the breath demand, this demand that facilitates the samples on the big breathalyzer at the police station, requires that the officer, number one, have reasonable and probable grounds to believe the person's ability to operate a motor vehicle is impaired by alcohol, or that they've committed an offense of being at or over 80 within 2 hours after ceasing to operate a motor vehicle. Very important that after ceasing to operate a motor vehicle requirement, because if you go home after an accident, you leave the scene, you drink alcohol, that's still a criminal offense because it's what your BAC is 2 hours after operating the vehicle. Obviously, there are concerns about this, but those are best left for another day and another video. What the officer has for reasonable grounds is going to depend on any given scenario. But again, it's the constellation of factors. The officer must subjectively believe the person is impaired, and that belief must be objectively reasonable. Oftentimes, you're going to look for things like, an odor of liquor, a lot of the same things as a suspicion, admission of consuming alcohol, maybe some witness evidence, bad driving evidence, slurred speech, fumbling with documents, flushed face, red, bloodshot, watery eyes, balance problems. All of those types of things are the things the officers are looking at. And if you have enough that the driver being impaired by alcohol is at the point where credibly based probability replaces reasonable suspicion, then they can go straight to the breath demand. The breath demand is also not required to be read immediately, and the tests are not required to be done immediately after the demand. Rather, the language used in the criminal code for this is as soon as practicable. And as soon as practicable means that the person is given the demand in a time period that is reasonably prompt in the circumstances. What does that mean? Basically, any activity that is necessary and relevant to the investigation can excuse any delay. So if the officer is searching the vehicle incident to arrest for evidence of impairment, that would be something that might justify delay reading the demand or administering the breath tests at the police station, or leaving the scene for the purposes of administering those tests. If the officer is facilitating contact with a lawyer, if the officer is conducting an observation period, all of these are reasonably necessary in the context of the investigation. Whereas if the delay is because the officer realizes he didn't order his kid's dinner and pulls out his phone and has to place an Uber Eats order to get his kid's dinner, that's not going to be related to the investigation and justify delay. So that's what you're looking at for the delay. Now, what also happens at the point of arrest that doesn't happen with the roadside breathalyzer is the right to counsel. And this is where a lot of people get into trouble, because the right to counsel, a lot of people think, is immediately required upon being detained by police. And that's mostly true, except when it comes to impaired driving investigations. If a police officer is doing a roadside breathalyzer, you do not have the right to contact a lawyer until after that breath test is conducted. Your right to counsel is suspended, and that's one of the reasons why there's this immediacy requirement. But the right to counsel is not suspended at the point of arrest and reading the the breath demand. At that point, the officer is required to facilitate contact with counsel, allow a person to retain and instruct counsel without delay. And in order to do this, the officer is supposed to read them a script or inform them of certain information. Number one, that they have the right to talk to a lawyer. Number two, that they can call any lawyer they want. Number three, that there's a toll-free 24-hour legal aid duty counsel service, regardless of income, available to somebody to provide advice. And number four, that they can have a reasonable opportunity to search for counsel if they want to choose counsel. When a person invokes their right to counsel, there's sort of this split in the case law in Canada. On the one hand, the case law in Canada suggests that facilitation of contact with counsel should be done at the police station to ensure privacy. On the other hand, there are a number of cases that say things like hospitals are not charter-free zones. People have the right to call a lawyer when they're taken to the hospital, and the officer has to facilitate that, find them a private space to make that call, kick the nurses out of the room, stand outside the door, wait until the person's done talking to their lawyer. And also, there are some cases emerging, especially in British Columbia, that suggest that the officer, given that cell phones are ubiquitous these days and there are very little places that no longer have cell phone service, the officer should be able to facilitate that contact with counsel at the roadside. Allow a person to use their own phone or the officer's phone, put them in the police car, turn off the recording equipment, and allow them to contact counsel. Now, whether or not you contact counsel at the police station or you contact counsel roadside, that's going to be something that your lawyer sorts out in the event that you end up charged. But it's always a good idea to invoke your right to counsel. You don't want to go into this situation blind and not having legal advice about your current circumstances. Once the officer has read the breath demand, read the person their charter rights, determined whether or not they want to contact a lawyer, and either facilitated that or decided to facilitate it later, the person then gets transported to the police station or the RCMP detachment for the purposes of providing samples. When they get to the police station or the RCMP detachment, the first thing that's going to happen before the samples are taken is that an officer is going to conduct what is known as an observation period. This is essentially a minimum 15-minute waiting period before the first sample is taken, and there is another waiting period between the two samples, required by law between the two samples, but not required by law before the first sample. And that waiting period is to ensure there's nothing that would falsely elevate the test result or interfere with the test. So the officer's going to check the person's mouth, and then they're going to monitor them to engage, to determine whether they engage in burping, belching, vomiting, regurgitation, or take anything by mouth. It's very important that they don't do this because otherwise it could compromise the integrity of the test result. When the officers do this, and when they are conducting the observation period, it also gives them an opportunity, because they've already either gotten a waiver of the right to counsel from the person, no, I don't want to call a lawyer, or the person's had their legal advice. It gives them the opportunity to essentially conduct an interrogation. You got to be sitting there, and the officer is going to be trying to ask the individual who's detained questions. Where were you? Where are you coming from? What do you do for work? And this is where a lot of people get into trouble. They start to get into casual conversation with the officer, and then all of a sudden they're letting more information slip that's detrimental to their case, or they're giving the opportunity for the officer to have recorded conversation where the court could hear the speech of the individual to determine whether or not it's slurred, hear the statements of the individual, assess their behavior, how quickly they respond to questions, all of those things. It's all generating evidence against yourself. If you ever find yourself in a police station waiting to do breath tests, it's very important to not answer questions from the officer during that observation period or at any other point. The only information you have to provide to the police is your license, your insurance, the name and address of the registered owner of the vehicle, if you're asked. Most of the time you're not asked, and your name and address, your contact information, date of birth, identification information, basically. That's all you have to provide. Beyond that, there is no benefit in saying anything to the police. You're never going to talk yourself out of a situation. I see people try and do it. It fails every single time. So, as I said, there's the 15-minute observation period before the samples are taken, and then there is the first sample, which is provided into the approved instrument, and then after that's completed, a second mandatory 15-minute observation period before a second sample is taken. Now, what are the requirements for the samples? They're required to meet certain parameters. Some of the parameters relate to the instrument itself, that it's using a gas standard that's certified by an analyst, a really technical requirement, that there's a blank check for the device, that the instrument has a system calibration check that is passed, a diagnostic test that is passed, and then you have the requirement that the two samples be 15 minutes apart. The final requirement that exists is that the samples have to agree with one another. This means that if your reading is 100 for your first sample, and in Canada we express it that way. We don't say 0.08 or 0.1. In Canada, you might hear that language a lot in the US and in media, but in Canada we would say 80. So, and that refers to 80 milligrams of alcohol in 100 milliliters of blood. So 80 milligrams percent, or 0.08 if you were to write that figure as a number. So if you blow 100 and then you blow 130, those samples don't agree because they have to agree by 20. So no more than 20. Anything more than 20 up or down is not considered to be a suitable sample. And if they agree by 20, that's just fine. So you could blow 100 and then blow 120, and that would be a suitable breath test, assuming all of those other conditions are met. Or you could blow 100 and then blow 80, and again, a suitable breath test, assuming all of those conditions are met. So basically, more than 20 is your magic number for determining whether or not a third or subsequent sample is required. And the legal obligation on the person who has been given the demand is to provide the samples. And it's not just to provide 2, even though 2 is what the law requires for prosecution. The requirement is to provide samples that are necessary in the opinion of a qualified technician, the breathalyzer operator, to enable a proper analysis to be made to determine the concentration of alcohol in the person's body. So you could be there blowing 6 or 7 times if you're not getting suitable samples. So just because you've done it twice doesn't mean that your interaction with the police is over. But in the vast majority of cases, the 2 samples are provided, they agree within 20 milligrams %, paperwork is prepared, and a person is then usually free to go. It's very rare that people are detained after an impaired driving investigation. Most of the time, they're going to be released with paperwork with a future court date and a date to attend for fingerprinting. Some circumstances, people may be held in custody until they sober up. Very rare, and usually only with chronic offenders, are you going to see somebody taken for a bail hearing as a result of an impaired driving investigation. There's no public safety reason, because in addition to taking the person in custody and testing them and giving them paperwork for a court date and paperwork showing their breath test results, the officer is also going to issue a driving prohibition. Most provinces or territories have some sort of immediate driving prohibition that follows an impaired driving investigation. In British Columbia, we have 2. There's the 24-hour prohibition, which says you can't drive for 24 hours. And then the second one is a 90-day prohibition that also starts immediately. So it doesn't actually make sense to issue the 24-hour prohibition, but it is done anyway, and that's just the way it is. So that's the circumstance. You're going to be released, you're not going to be allowed to drive, the vehicle's probably impounded for a minimum of 24 hours, and then you go home, you sleep it off, and hopefully contact a lawyer and get the legal advice you need in the morning to start the process of disputing it and gathering information that's relevant to your defense. That's basically how impaired driving investigations unfold in Canada. There are other types of investigations, such as drug recognition investigations involving impairment by drugs. We will talk about those in an upcoming video. And there are also investigations where people are taken to the hospital and blood samples are provided. And we'll talk about that in another video as well. Hopefully that clears up a lot of information about how impaired driving investigations tend to unfold in Canada.